Not all trusts are created equal, and some aren't even real. If someone told you that a common law trust can help you avoid taxes or government oversight, well, it's time to check the law. Hi, I'm John Strohmeyer with Strohmeyer Law, where we help our clients leave no unfinished business. While I am a lawyer, I am not your lawyer, so don't take the advice of some talking head on the internet. Remember, you need to talk to your own advisors about your specific circumstances. Also, remember to like, comment, and subscribe. Now, today we're going to be talking about what actually governs trusts, not only federal law, but Texas law, where I practice. What we're getting at is why common law trusts, pure trusts, constitutional trusts, things that people say get out from a statutory framework really aren't a thing, why they're not a separate category. Why are we talking about it? Well, it can ultimately lead to waste and problems for you and your family later on because trusting in these fake legal categories can lead to bad plans, IRS trouble, and expensive cleanup. So let's start with our governing law. I'm here in Texas, so what are we thinking about? Well, in Texas, trusts are governed by the Texas Trust Code, which is part of the Texas Property Code. Section 111.004, subsection 4, defines an express trust as a fiduciary relationship arising from the settlor's intent to create duties for someone holding legal title to act for the benefit of another person or a specific purpose. In other words, an express trust is when someone intentionally creates a trust relationship. So that someone who creates it, called the settlor, sometimes again called the trustor or the grantor, depending on where you are, they're creating duties for someone who's holding legal title, known as the trustee, for the benefit of another person, that beneficiary. Now, section 111.003 clarifies that only express trusts are governed by the Texas Trust Code. Resulting trusts, constructive trusts, and business trusts are specifically excluded from this because they're arising from different portions of law. What this means, resulting trusts, constructive trusts, and business trusts don't count. What you didn't hear in there are express trust, pure trust, or constitutional trust. And every other trust that's created by a settlor is going to be an express trust and governed by the Texas Trust Code. So you can't intentionally create one of those trusts and have it be exempt from the Texas Trust Code. That statutory framework is going to apply. So anything labeled as a common law trust, pure trust, constitutional trust isn't going to have some separate exemption that gets it out of this framework. So how do we know this applies? Well, section 111.006 confirms that the Texas Trust Code applies to all express trusts created on or after January 1, 1984. Even older trusts are going to be subject to statutory oversight for any transaction after that date, and will have different laws that apply to them before that date. So if you hear someone saying, well, there are these older trusts, yes, there are older trusts in different jurisdictions that have different rules and different applicabilities. Yes, there are trusts in England that have been around for centuries. They're different. Once you've got a trustee who's here in Texas, then guess what? You're going to be subject to Texas trust law. And this is going to apply whether the trust is revocable, irrevocable, or created under a last will. There are no special legal carve-outs that apply anymore that's going to let you opt out of statutory control by calling it a common law trust or a pure trust. Again, if you've got a trust and there's a trustee in Texas, it's going to be subject to the Texas Trust Code. You say, well, we've put it in a different state. Guess what? There are similar provisions in those other states. I'm not talking about them because I'm not licensed there, but the point is that you have those statutes that are governing these trusts. So no matter what, you've got a framework that's in place if that trust agreement doesn't line out what needs to be done. So things like how trustees are appointed, how distributions are made, and how beneficiaries' interests are ultimately protected, well, it's a statutory framework that replaces what is out there. This doesn't mean that these aren't somehow subject to the common law created by courts through judicial precedent. Those common law decisions come out as they're reported and then can modify what happens. But what it doesn't mean is that even though those common law decisions, precedential value of judicial decisions that applies to these trusts, doesn't create a separate framework. The Texas Trust Code is going to apply to those trusts. So we're getting at common law in Texas really is not applying to what these promoters are claiming when they're talking about a common law or constitutional or a pure trust. Texas does follow a common law legal system like the rest of the United States, except for Louisiana and most of the former British colonies. Court decisions or judicial precedent are going to form part of the law alongside those statutes. You have to read them together. This doesn't mean there's a special category of common law trusts that escape government regulation or escape the statutory framework. So the phrase common law trust is not a term of art in Texas, really, or anywhere else. It's not recognized as a distinct or separate category. Basically, every valid trust is going to have to operate within the Texas statutory law and is subject to judicial oversight and further court decisions. So that's Texas law. Let's start looking at federal tax law, because guess what? That applies to all those Texas trusts too. Again, the IRS is not going to recognize common law trusts as tax exempt or outside of reporting rules. Trusts are taxed under Internal Revenue Code section 641 to 683. And again, those specific rules will depend on the specific structure. Generally, trusts are going to be classified as either grantor or non-grantor trusts. And if they are a non-grantor trust, then they're either a simple trust or a complex trust. Again, it's going to depend on certain rules inside that trust agreement. What there isn't is a federal tax exemption because something is labeled as a common law or a pure or a constitutional trust. And that doesn't mean, well, it's not addressed. It means the rules address the forms that are out there. And we also have judicial precedent. Again, go look at Markosian and Aldridge for examples of cases where if the trust tries to exempt itself, well, the courts can still come back in and say, this either works and we're going to address how it was structured, or the trust can be disregarded because they didn't do anything. There was no change in the economic substance of the transaction or the relationships. And so they're disregarded. Federal tax law is still going to apply. There's not going to be a rule that gets you outside of those trusts being subject to income tax or being subject to estate tax. And so, no, there's not a special rule that will get you out of paying income tax as it comes due because, well, 641A of the Internal Revenue Code says trusts are going to pay tax just like individuals. Yes, there are some modifications, but there's not going to be any deferral and there's not going to be any exemption from income tax. So how do those trusts fall apart? I mentioned a couple cases before because it's important to note that for federal tax purposes, these trusts can fall apart under IRS and court scrutiny. I mentioned Markosian. Well, the tax court back in 1980 disregarded a trust that the taxpayer had set up, controlled, and benefited from. Guess what? The income remained taxable to him. It didn't matter that there was a trust in place. In Aldridge, a much more recent case from 2024, well, the court rejected a sham trust system and ended up imposing $650,000 in back taxes plus $500,000 in civil fraud penalties. These are just examples of cases showing that the courts are looking at substance and not the form of what's going on. So if the taxpayer is keeping control or benefit from those trusts, they're not going to work as a shield or even any sort of effective planning. Ultimately, courts aren't going to uphold a trust as valid simply because it's labeled as common law or pure or constitutional. And not only are they not going to uphold it, they're not going to respect it. So what happens if someone says, look at these trusts? When promoters cite court cases, they're generally looking at particular case law that says a trustee can allocate income to principal or certain little bits that, while true on their own, don't explain things in the full context. Additionally, older cases may not apply at all because they've been overruled by later cases, later law, or later constitutional amendments. Just because there's a case that says something, it doesn't mean that it's still effective law. Ultimately, here in 2025, we don't have any relevant case law, Texas or federal, that upholds the concept of legally distinct trusts that somehow can avoid being entwined in the Texas legal system or the federal legal system. Now, again, promoters may cite general constitutional provisions or cherry pick phrases, but they're not going to provide the real precedent that shows that these things work. So, recapping, all express trusts are governed by Texas statutory law here in Texas, regardless of their label. If you go to a different jurisdiction, guess what? There's going to be a similar provision there. There's not going to be a separate common law trust category that allows you to avoid tax or skip compliance. Beyond that, the IRS and the courts are going to look to who controls the trust and who benefits from them. Labels aren't going to matter, the facts will. So if you want a trust that actually works, you're going to have to start with the actual law, not the marketing. So thanks for watching. Be sure to comment, like, and subscribe, and don't fall for bad legal advice disguised as loopholes. We'll see you in the comments.